Welcome to our webinar, Cybersecurity Compliance for Higher Education 2018 and Beyond. We are ready to get started, so let me turn it over to our host today, Mr. Rob Van Arnhem of the law firm of Williams Mullen.
Thank you, Patty, and good morning, everyone. I'm Rob Van Arnhem. I'm a partner and co-chair of the Data Protection and Cybersecurity practice at Williams Mullen, and we have a great program for you today, and we're pleased to have you join us. Let me just give a brief introduction of the two partner firms presenting today. At Williams Mullen, we're a regionally based full-service law firm with 230 attorneys, and we have a multidisciplinary team of lawyers that can handle any aspect of institutions' legal needs, including data protection and cybersecurity. And I wanted to briefly highlight our higher education practice that does a lot to serve the legal and regulatory needs of various colleges and universities, not only here in the Mid-Atlantic, but beyond. And with us as a special guest is Sera-Brynn, which is a global cyber risk management audit and advisory firm. They deal with PCI and QSA and third-party assessment certification. We have teamed with them. They're also Fedramp certified, and they are founded in 2011 and doing a lot of great things, both in audit and cybersecurity, and we have partnered with them several times on data breach incidents. So again, we're pleased to partner to present to you today. I also wanted to introduce our speakers, and it's a privilege to have joining me today two individuals who are experienced working with companies and universities and other institutions of higher education, addressing numerous privacy and data regulation challenges they face. First is Heather Engel. Heather is the Chief Strategy Officer at Sera-Brynn, and she has over 18 years of experience in risk management, information assurance, business continuity planning, and security program development. Prior to Sera-Brynn, Heather assisted government agencies and the DoD in securing advanced information systems and developing cybersecurity programs. She is certified in essentially all qualifications for security personnel, originally from Binghamton, New York. We are really pleased to have her today. And also with us is my colleague and partner, Tony Anikiff. Tony is the co-chair of Williams Mullen's government contracts practice. He has more than 20 years of experience representing domestic and foreign companies, conducting business with the U.S. government and state governments. He advises contractors, subcontractors, third-party stakeholders, including universities and colleges, regarding many of the issues that rise dealing with the government. Well, let me also just highlight today's agenda. We intend to, as quickly as we can in the brief hour that we have, talk about compliance challenges for colleges and universities. And that includes the current and emerging regulations that you're dealing with, and the impact to research and academia, and the practical steps to implementation. And finally included that the legal analysis and discussion of some of the more urgent and recent compliance issues you're facing. Administratively, the question feature, the chat feature is at the bottom left of your screen throughout the presentations. Please feel free to chime in with questions, and we hope to leave enough time at the end to answer all of your questions. If not, we'd be glad to follow up with you directly via email, and at the end of this, you will see our email addresses. We'd love to stay in touch with you. All right. Well, it is no surprise to you that your college or university, wherever you're coming from and joining us today, that you gather and maintain a huge amount and varied scope of sensitive data. And that could be student records, coursework, credit card payment information, to things like research, health information, government records, and research. Institutions like yours, and especially very large universities, are like complex companies divided into multiple affiliates, each with their own legal requirements and security challenges. Those regulations include what I described as the alphabet soup of overlapping government rules, some of them depicted on the slide in front of you, and a few of which we'll be able to cover today. That could be DOE, DFARS, FAR, FERPA, GLBA, HIPAA, and most recently, GDPR. Additionally, universities have unique challenges institutionally dealing with how to enact compliance programs in the political structure that they're in. First and foremost, budgets. All of this has to be done at some cost and has to be justified. Obviously, we encourage you to include the cost to upgrading systems and conducting audits and reaching compliance in your RFPs and any proposals submitted to the government or for grants. As a little bit of ammunition for that, hopefully you can convince your stakeholders that the costs of compliance are much cheaper than the cost of dealing with a breach, which in a recent report from Ponemon Institute finds that the average cost of the breach is $141 per record, which is actually a decrease from last year, but the average size of data breaches has increased to more than 24,000 records per breach. Also, the lack of coordination. I think universities and colleges, perhaps like a law firm, are fairly flat organizations where everyone has an opinion, and trying to harness all those different ideas in management when you represent a cost center is difficult. But again, approaching privacy as an investment and compliance as an investment, not just as a cost, is something that we can help you do when you're talking with your internal constituents. And also approaching compliance and privacy not just as a fort with walls to keep the outsiders and hackers out, but also if there is a hack, if there is an intrusion, that hacker is limited in what they can get. Not all employees should have unrestricted access to the vault and to the database and the huge amount of data and records that universities have. We encourage you to keep that as limited as possible. I know many have started down that path. There's certainly more to do. As I mentioned, I wanted to highlight GDPR compliance, and that could be its own webinar, but I'll just highlight it briefly. Many of you should know by now that the EU set an effective date of May 25th, which is right around the corner, for the General Data Protection Regulation, and that replaces the Data Protection Directive of 1995, and it significantly expands personal privacy rights for EU residents. Not only is GDPR more enforceable, it applies to entities with no physical EU presence, so that broad territorial reach. And that is for those that controllers or processors of data dealing with EU residents. Those of you, for instance, with EU residents as applicants and students or distance education programs with students from the EU are going to be subject to these new regulatory requirements. And they are much more robust and difficult than the previous directive. For instance, the GDPR requires a documented understanding of why information is held. It's much more of an affirmative duty than previously. How it's collected, when it will be deleted. Breach notice is a quick turnaround time frame of generally 72 hours of discovery for controllers and without undue delay for processors. I think most people attending today would fall in the category of controllers. And while it may seem irrelevant to U.S. colleges and universities, institutions of higher learning, you are getting applicants, you are dealing more and more with EU residents. And again, institutions with significant engagement with the EU, with abroad programs, even without a physical presence, are going to really have to pay attention, and hopefully it started the process of compliance. I just wanted to briefly touch on a few takeaways that GDPR requires. First is a data protection officer, and that's only mandatory in certain instances, again, where processing is carried out by a public authority or body where the core activities of the controller or processor consist of processing operations. The real takeaway here is that even if it's not required, it may be a good idea. It is essentially the ombudsman of data protection and the person who can regulate and control and be the point of contact for all things GDPR. Second point, upgrade and document security measures and notification procedures. Like many compliance exercises, this is CYA. While there will be a hack and you won't ever be able to completely prevent it, you can be prepared and have a breach protocol, ensure your compliance program is up to date so that you can show auditors that you have done all that you could. Upgrading your agreements with vendors, ensure your agreements reflect GDPR requirements. Apportion that risk via indemnity and make sure that the people primarily I think that you would be dealing with are vendors and processors. Are they ready? Have they taken the steps necessary to be compliant if they're dealing with EU residents? Establish process and rules for granting subject access. There's a lot in GDPR about consent and subject individuals being able to access their own data and also requested it to be deleted. Fifth, documenting compliance with legal requirements, and I like to say in the discoverable dossier, so show how you are complying, not just your gaps and vulnerabilities, and ensure that you have counsel as part of your audit team to maintain privilege. Updating privacy notices, the biggest issue here is cookies. So as part of GDPR, IP addresses and things that weren't typically used to identify an individual are considered to be personal data. And so cookies, as an example of website policies and protocol, are used in a way that's usually there's been implied consent, it's been passive. Many institutions use them for all types of analytics and advertising and functional services. But to become compliant, it needs to be an affirmative consent, not just implied. So on your site, you must specifically ask and have a click-through or opt-in box about whether the subject is willing to be share their data via cookies. And then finally, appointing a local representative. And I think that may not apply to most of you. There's some nuanced regulation about whether you have established operations in the EU, whether you're offering goods or services, even if you're not doing that from outside the European Union, it is whether it is reached inside, and then monitoring the behavior of certain EU residents. GDPR is a big subject. We may have a separate webinar on it, but without further ado, I want to pass it on to my colleague, Heather.
All right, good morning everyone, and thanks very much, Rob, for the introduction. What we're going to be talking about today is initially we'll just discuss various regulations that apply to personally identifiable information, financial data, research environments, and although we'll be discussing specific compliance controls today, I'd like to stress that the goal is not to limit research or limit the expansion of things like distance learning programs, but to really help you with understanding and interpreting the controls as well as protecting the data. We want to do this in a way that's scalable, that works for your individual organization, while you are limiting risk and decreasing the impact should a data breach occur. These are the relevant regulations that we're going to talk about today. Rob covered GDPR very thoroughly, so we'll gloss past that one. The other three, we'll talk a little bit about how they're related and why they're important. As Rob mentioned, you have compliance by May 25th of this year, and really if you have a distance learning program or if you have an EU base, you should already be in the process of implementing your GDPR practices. That's really the takeaway from this slide. So we'll spend a little bit of time talking about FERPA and GLBA. As you all know, educational institutions have to adopt an information security program, including appointing a security program coordinator. And that is a theme that you will see consistent throughout the regulations that we're going to talk about today. The Department of Education has said that compliance with FERPA equals compliance with GLBA, and this covers financial aid, credit cards, and any form of customer financial information. In a letter that was issued in July of 2016, the Department of Education Federal Student Aid Office, this is their Dear Colleague letter, and if you have not had a chance to review this, I would recommend that you look at it, just read through it. They strongly recommend assessing your systems and processes that handle these data types against Nist 800-171. And we can read that as a clue that we are going to see more federal regulation here. If you fall short of the requirements in Nist 800-171, they are strongly recommending that you are taking steps to close those gaps. And we'll talk a little bit more about what some of those gaps are in the next several slides. All right, so let's spend a little bit of time discussing Nist Sp 800-171. This is a regulation that is near and dear to our hearts. We've done a lot of work with numerous clients over the last several years on this regulation. This was put in place and designed for commercial or non-federal information systems, and it really focuses on confidentiality. It has 14 control families, 110 controls. And it seems fairly straightforward when you read through it. However, where most organizations struggle is in the interpretation of these controls. So as with many other compliance mandates, there's a lot of room for interpretation. This is going to present challenges if your risk tolerance is something that is unknown. As I said, the goal is to protect data confidentiality, as well as have the infrastructure in place to identify and respond to a potential security event or a data breach. We know from working with our clients, and it's been published many times over, that the time to discover a data breach is very often 6 months or more. Implementing the steps in Nist 800-171 is designed to dramatically reduce the time to discovery. And you'll see that when you start to read through some of the controls, not only on incident response planning, and as well as training, but also when you're looking at auditing, when you're looking at account management, when you're looking at securing the boundaries of your system. Some of the controls from Nist 800-171 that have been the most challenging for our clients to implement include multi-factor authentication. That's a big one, and even clients that we've worked with and that we have assessed who are at 95% are still struggling in some cases with multi-factor authentication. I already mentioned auditing. Again, you will not see any requirement for a specific tool, and you typically will not see specific information on what length of password you have to have. But you do need to maintain records. You do need to be able to identify and parse through a very large amount of data when it comes to auditing. And so in this case, or in some instances, a tool may be useful here. Media protection and marking and just the use of removable media is something that many organizations have struggled with, both on the research and academia side as well as our commercial clients. This is everything from thumb drives, removable media, CDs. All of that has to be controlled and marked so that you have a good understanding of where your data is and how it's leaving your organization. So if it goes outside of that protected boundary, how are you going to maintain the confidentiality of that information? Encryption is another one that we've had a lot of questions on, and we've worked with a number of clients on what specifically do they need to encrypt. Do they need to encrypt data in the first place? And in many cases the answer is no, you do not, if you have other controls in place to protect the confidentiality. And then finally, boundary protection, particularly when we're working with complex institutions where, for example, in a research organization, there are very different requirements across projects. Understanding the scope of your network and your environment and protecting those boundaries accordingly is something that a lot of our clients struggle with. I will mention, and this is not an endorsement, I've not personally reviewed this product, but Splunk, if your organization is already using that for audit and log management, has a free campus compliance toolkit that is specifically built for Nist 800-171. So again, if you're already using that product, that might be something that is useful to check out. All right, so we'll spend some time now talking about Nist 853 and the Fedramp program. The reason that we're going to talk about this is because many of our clients have found that if they are storing protected data in a cloud, that presents issues with overall compliance. There is an acquisition clause that's been put forth by the Department of Defense that mandates if you are storing CUI in the cloud, that cloud service provider must either be Fedramp authorized or they must attest to have implemented equivalent security measures. The Fedramp program runs off of Nist 853. Again, this is a much, much larger document than Nist 800-171. It addresses not only confidentiality, but as well integrity and availability of data. And so this is difficult for clients, especially if you're using a cloud service for backups, or maybe you have your email in the cloud. If you are doing that with a cloud service provider that has not either attested to equivalent security measures or is Fedramp authorized, then you're going to need to look at an alternate solution as you go forward. The Fedramp program is a standardized approach to assessing and authorizing cloud service providers for government use. As of right now, again, you do not have to have Fedramp authorization, but you have to have equivalent protection. There are a lot of software as a service clouds that are authorized, but really if you're talking about storage, so backups, recovery, email, data being stored in the cloud, you really have three choices. Amazon Web Services, Microsoft, and Google are the big three there. All right, so we're going to talk a little bit now about the impact to research and academia. And again, the goal here is not to limit researchers. It's not to limit the growth of programs, but to develop a process that identifies a data owner, identifies a system owner, and then applies controls to the environment to meet the regulation. Limiting the scope or boundary of your networks is going to help a lot with control interpretation. If you don't understand what you are trying to apply the control to, it's going to be very difficult to, one, determine your risk tolerance, and two, determine what is an appropriate level of protection. I'd like to point out, too, that in system environments, particularly in a research setting, one size absolutely does not fit all. Some research projects may just require a standalone laptop and no internet access. Some may require high-performance computing and connection to other data sets or databases. And so what is very important here is when you're looking at how you're going to implement this and understanding what's already being done in your organization, we really need to plan to scale. Without that plan to scale, managing this can quickly become overwhelming, particularly at large institutions where you may be bidding on multiple research contracts. Having someone in the mix who can negotiate that contract, who can truly help you understand what type of data is being provided to you that requires protection, is going to be critically important in making sure that you are able to protect the data accordingly. I'd like to talk here for just a second about the CUI registry. And so the CUI registry was released and finalized several months ago. And in that you'll find a number of categories of what is considered data that needs protection. Some research projects may have controlled technical information. There are 22 other categories in addition. Some projects may have controlled technical information as well as protected health information, or it may apply to some of the other categories. It really just depends on what types of projects are being done. So if you work in contracts, if you work in compliance or research or export control or IT, it's worth just taking a look, and we have the link here on the slide. It's worth familiarizing yourself with the general categories in the CUI registry. You can always go back and look at them in more detail. The slide that I'll bring up here just shows you the controlled technical information description. It's very dense. What we've highlighted in here is the technical information with military or space application is considered controlled technical information, but that is a very broad definition. And so again, negotiating the contract and understanding what's in the contract is going to be very important here. One other category that I'd like to point out in this context is the protected privacy and health information, and it specifically, again in here, highlights schools and universities, so university health systems. Whether or not research is done that's being, that is affiliated with protected health information, your health system is specifically identified in this category. And again, that's another indicator really that we're going to see Nist 800-171 become applied more universally as we move forward. You know, the ripple effect here, what we're seeing and what universities are facing now is challenging. You've got multiple regulations that apply to different data sets, but there's a lot of crossover. You heard Rob mention that there's a 72-hour window for reporting data breaches under GDPR. You also have a 72-hour window for reporting data breaches if you're working with controlled unclassified information. The method for enforcement and penalties for all of these is potentially severe. We know that the DoD CIO has stated they're looking for a system security plan and a plan of action and milestones. If you are familiar with the Defense Federal Acquisition Regulation that mandates protection of CUI, you know that the deadline for protecting and being in compliance with Nist 800-171 was December 31st of last year. If you have a system security plan and a plan of action and milestones, that is a good first step. However, you need to still be showing now, 2 months into 2018, that you're making progress with what you've put there and what you put in your plan of action. Again, research with federal healthcare dollars may include additional provisions for security, including FIPS 199 and other assessments. So what you're really facing here is regulatory pressure from a lot of directions. You have multiple data sets, sometimes with overlapping regulations. And so how do we manage this? I'd like to take a look at one more category from the CUI registry, and that's student records. Again, another indicator that Nist 800-171 is going to become more important and really is being held up as the standard when you're dealing with protecting information that is a CUI category. All right, so let's get to what everybody's been waiting for, I think, and so we'll talk about some practical steps to implementation here. Some of the immediate steps that you can take if you are a research institution. I've got a few questions for you that it's important that you know the answers to these questions. And so the first would be, who has the lead on these efforts? Is it going to be your Office of Compliance? Do you have a research office? Is it a joint effort between compliance, research, and IT? It's important to understand what types of research are being done now at your organization and what is your strategy for growth. So if, for example, you're primarily focusing on research with controlled technical information, but you plan to branch out into other areas, how is that going to impact some of these requirements? Are you going to then be looking at additional categories of CUI? Many of our university clients have told us that they really feel that they could potentially be doing research in almost every category of CUI. And if that applies to your institution, again, that's something to look at as you plan to scale the infrastructure that you're using here. The next thing to look at is what type of information technology support is being used and is it sufficient? Very, very often our clients are finding that a virtual or a high-performance computing environment in the cloud has been an efficient way for them to onboard multiple research projects. Again, I would point out that if that cloud environment is hosted externally and it houses CUI, you need to consider Fedramp. What many of our clients are doing is hosting virtual computing or virtual resources internally. In that case, Fedramp does not apply. However, if you are planning to lease space external to the organization, then that may come back into play. So lots of things to consider here as you look at your environment as it is today and as it will be going forward. I'd like to share with you now an approach that we've used with many, many clients both across the university space as well as in the commercial space. And this is the risk management framework-based approach as applied to research. This is a recognizable framework. Anyone who is in the government space or who has a background in this will tell you they've heard of the risk management framework. Essentially what we're looking at are 6 steps, and these are repeatable steps. It's flexible. It accounts for both risk and responsibility, which we've already said are really key in planning how you're going to address these regulations. I think most importantly here is using this approach allows for risk tolerance. So you're interpreting your NIST controls based on the organization's risk tolerance. And if, for example, in one of the steps for implementation, maybe there's a project or a research program that's coming on board where you're not able to implement all of the controls as has previously been interpreted and discussed. In that case, there is a method here where you can still accommodate that project by choosing to accept a little bit of additional risk. And so we'll talk through this framework here just very briefly. The first step is categorizing your data, understanding what type of information you have. And this is something that's typically going to be done at the research level or by the data owner. Very often compliance will be involved in this. If it's technical information, you may have export control officers or folks who have expertise in that area who will all contribute to understanding the category of data. During this step, this is also when you're looking at your contract. If the contract is not something that's been signed yet, this is where you're working on the negotiation, where you're really understanding the finer points of what needs to be done to protect the data. In some cases, you may be able to negotiate down some of these clauses, just depending on the type of information that's being given. Once you understand the category of data, you're going to select the security controls that apply, and this may be specific research information environments. So maybe you're looking at, do we need a standalone laptop or do we need a cloud service environment? Once you've selected the appropriate environment, you can apply the various security controls. We already mentioned there's going to be requirements for access control, system and boundary protection, auditing, communications. All of these are things that you're going to look at based on the information, based on the risk, based on potential threats to the environment. And then we're going to select the controls that are going to apply here from that set of 110. What many of our clients are doing is they have a standard set of those 110 controls, and then you'll see in the next block where we talk about implementing the security controls, there's a shared responsibility matrix. And so what's really going to happen, particularly if you have some sort of high-performance computing environment, is there are going to be a number of controls that are going to be the responsibility of information technology, but there are going to be several controls that are policy and process related that really fall back on the researcher or on the Office of Compliance to understand how those are going to be implemented and enforced. Some of those would include training, policy, restriction of removable media. All of those are going to be part of your shared responsibility matrix where you're really understanding who's doing what in terms of implementing the security controls. In the DoD, there's typically an external third party to the research or to the system and data owners who is going to help with validating the security controls. In many university settings, that's going to be your CISO, your Chief Information Security Officer. So you're going to have IT and you're going to have the researchers implementing the security controls according to that shared responsibility matrix. And then the next step is to validate that those controls have been implemented and are functioning as intended. In this way, you're bringing in someone who is more of a neutral third party to ensure that those controls have been applied and that everyone involved understands how the data is being protected. That person then is going to communicate to the person who's going to actually authorize the information system. So what we're finding is that in most complex organizations, there needs to be someone, and I think Rob endearingly used the term CYA earlier on in the webinar. You're going to have someone who is responsible for accepting the responsibility for operating this information system. Maybe it's the CIO, maybe it's the president of the university. It depends truly on the organizational structure and the size. Once we've accepted the responsibility for operating the system as it's designed, and again, if you're not able to implement some of the controls, that's not a deal breaker as long as the person who is authorizing the information system use really understands the additional risk that is presented by not implementing those controls. You can still authorize the system and you can still move forward with the project. Once you've authorized the system, you're going to move into the monitoring phase, and this is really the continuous monitoring approach that is the heart of the risk management framework. This is where we are looking at our log files on a day-to-day basis. This is where we're taking steps to proactively address system security events, potentially elevate them to incidents, and really protect the data moving forward. Some other immediate steps for general compliance, and these are just some takeaways. Recognize that data for the majority of students will fall under at least one mandate. If you've got an ROTC program, if you've got a student who is on financial aid, we already talked about foreign students who may have applicability under GDPR. You're going to need to plan for all of these. And remember, consistent throughout the requirements is a requirement to appoint someone with the responsibility for data privacy and security. And that's really, really important here is the second bullet. There has to be someone who is in charge, who has the authority to pull in resources, both internal and external, and as needed. And it may be one individual is spearheading this, or maybe one person asks the question, and then from there you develop a team or an office who can address these things. But the good news is there are a lot of consistencies among these different regulations, and again, the ultimate goal here is to protect the data. It's not to limit research. These regulations, for the most part, are written in a way that you can do that with interpretation against a good, solid risk assessment. And so with that, I'm going to turn it over to Tony. He'll give you a little bit more information on the legal aspects of these different mandates, as well as talk a little bit more about some of the acquisition regulations. Thanks very much.
Good morning. Thank you, Heather. Heather Engel's giving you a robust insight into many of the practical aspects of cyber and privacy considerations pertinent to higher education. I'd like to spend a few minutes delving into the current and evolving legal framework which has brought about these obligations with which you're required to comply, and then a little bit of a look at the horizon. A little bit dry, indeed, but persuasive fodder for those of you who might be counsel or CISO or others involved in this area in trying to persuade stakeholders that they need to account for these obligations in their budgeting and to explain to your colleagues what they're getting into when they endeavor to engage with the government to seek some of these additional resources. In terms of context and agenda, we're going to touch upon the overall context in which institutions like yours operate in dealing with the federal government and others. We're going to look at the goals of the government cybersecurity system, its legal framework, and the government's particular focus on what we've referred to as controlled unclassified information, and then some of the policies and rules and other rules which Heather and earlier Rob alluded to. So first, by way of context, we of course appreciate that most universities are seeking to increase their R&D dollars from the U.S. government as a particularly good resource of funding. Also looking to states and local governments which may have their own rules. In doing so, universities and research institutions generally engage with the government through contracts or grants, and it's going to be those terms which are going to establish the obligations with which you need to adhere. Those terms are usually mandated by government regulatory policy or structure or rules, and as Heather noted, what the government's looking at and what they care about is the fact that you as an institution possess and receive a great deal of information which the government and others may consider to be protected or private and require some control. As a contractor, you are going to need to be aware of whether these rules and policies look at regulating the way you handle the information or are they looking at the system which you're operating in which the information is held? And then, of course, I mentioned the possibility of state and local government. There are a host of other rules that deal with privacy, HIPAA, state and local rules, and the European Union as other rules that might affect you. So the overall context. From the perspective of the government, they have two competing interests. On the one hand, they're required to protect information that they receive from a host of people, individuals, universities, research institutes, and the like. On the other hand, in order to carry out its function, they need to be able to share protected information with researchers like you, developing technology, conducting studies, and other things. That protection can't stop at the border of the government's systems. It has to find a way to gain protection in various private sector institutions like yours. How that affects you, of course, is going to depend on several factors. It's going to depend on who your customer is, i.e. what type of agency, federal or state. It's going to depend on the sensitivity of the data and the consequences of theft or misuse, i.e. sensitive, controlled, unclassified information or publicly available information. And last of all, the nature of your assignment, what it is that you are undertaking to do with respect to the government. For today's conversation, what we're focusing on is the sorts of information that you as an institution are most likely to possess and the manner in which you are most likely to handle it. And that's really dealing with what's essentially in large terms sensitive classified information, and then it's a term of art that is processed, stored, or transmitted through private information systems. And when we refer to that, what we're talking about are your private information systems as opposed to a government agency system or a contractor that has been hired to operate a government information system. Those latter two categories are subject to a different stream of regulations that tend to have more government-unique aspects to them. Here, what we're talking about is the regulation of information systems rather than the information. And so what we'll be talking about is the system and how the government seeks to set up a policy that can be applied across all of these private systems. We're also dealing with defense and civilian agencies rather than the intel agency. And as I noted a moment ago, there are different regimes that apply to the regulation of information. Rules that apply to PII and HIPAA tend to focus on what you need to do with that information, and they may be separate and apart from the obligations that we're going to be discussing today. So if you look at what the cybersecurity system goals are from the government's perspective, is that at the moment it operates as somewhat of an ad hoc system just because of the evolution. What they're hoping to get to in conjunction with discussions with industry is a standard cybersecurity system applicable to types of covered information. And then the idea of protection through means that are familiar to business and academia without unique government attributions. In other words, trying to use the kind of measures that a prudent business would use in trying to protect its own information. And then third, there's an effort to try and develop an effective reporting system to the government so that there can be an appropriate response. So what I'd like to do, and to better understand all of this, is to understand briefly the legal framework which has led to the system that Heather was talking about in her discussion. And it all started back in 2002 with this act called Fisma. It's a very broad-based statute that really says that agencies are required to identify and protect information security in a manner that's commensurate with the risk of, and it goes on here in the statute, of disclosure or misuse or improper access. The statute itself deals not only with the kind of information that we're talking about today, which is private systems being operated by private entities, but also government entities and the like. And so it leads to different streams of regulations that have followed. The powers that be in the government have decided that controlled unclassified information falls into the moderate range of risk, and therefore it's something less than classified information and something more than generally public information. This statute, in its general terms, has been implemented through an evolving array of regulations and policies. It started with a 2010 Executive Order 13556, which created this concept of controlled unclassified information and really launched a program of the National Archives and Records Administration for managing information which law or policy requires safeguarding or dissemination controls. That's the beginning. From there, NARA, the shorthand version of the National Archives and Records Administration, issued a regulation which went into much greater depth of how to go about agencies designating and safeguarding, disseminating, marking, decontrolling, and otherwise handling this controlled unclassified information. It also led to the issuance of the Cui Registry, which Heather spoke of a few minutes ago, which is this body of 23 categories of information which, if you go look at it, covers a vast array of information. Building on that, the National Institute of Standards and Technology, which is really the government's body that creates various standards that can be applied throughout the government, has come up with a standard 800-171, which we've been talking about a great deal today, which establishes the security requirements for protecting Cui in non-federal information systems and organizations such as yours. What's interesting to note is that although these are the aspirational goals and the desired regulations that the government would like, none of these particular regulations and policies are self-executing or applicable to a contractor because they haven't yet been incorporated into the FAR, except as we're going to note. So, how they've gone about applying them to contractors and institutions like yours has been some of an ad hoc process, and we're going to talk about these a little more in detail in a minute. And agencies have followed various means to implement the Nist and the Cui regulation. The FAR was established as a baseline that covered all parties and establishes a system of really prudent controls that we'll talk about in a minute. The Department of Defense is the first agency to go out and establish a comprehensive program for contractors covering both the protection of Cui and also creating a cyber reporting system. Other agencies have developed internal policies which have resulted in somewhat of a hodgepodge of contract provisions that you find if you're doing business with them. Perhaps the one that's most notable is the CDC, which one finds goes on with pages and pages of regulations. What's going to happen in the future in this vacuum is that the GSA and the Department of Homeland Security, which already have contract clauses through policy, are going or in the process of developing and formalizing these policies and regulations. The ultimate lodestone or rule that's going to come out, we hope, is the NARA regulation, which will provide a government-wide FAR regulation that will mandate the installation of the Nist 800-171 to all contractors. So we've talked about this concept of Cui. The government has focused on this term, controlled unclassified information, as really the foundation for what we're talking about. And it's very broad when you look at it. It talks about government information that is possessed or that someone creates for it, that a law or regulation or policy, and this is key, requires or permits an agency to handle using safeguarding or dissemination controls. If one looks at the 22 categories that come under Cui, one can see that a great deal of information that you're going to deal with in the research area, or the information that you hold on students and others, and your financial information, as Heather talked about, is going to fall into this category. The other thing that's important is that it's a self-designating system. And the challenge that people encounter is that concerned, maybe in the CYA context, people self-designate documents and data as CUI and therefore bring it under the regulation in situations where that might not always be necessary. So Heather talked a good bit about this, so I will gloss over it a bit. But this is what it all comes down to, and this is what ultimately the narrow regulation is going to impose on everybody, and the other agencies to some degree are imposing through a haphazard manner now. The idea is to create a more secure system to protect the confidentiality of Cui. And as Heather noted, there are other regulations that are intended to focus upon the integrity of the information and the availability of the information. Here we're focusing on keeping it confidential. And there are 14 families which we've set out here, which basically cover the physical, personnel, and digital aspects or universe of what you're dealing with. And within that, there are base requirements, which are sort of the core concepts of protection, and then derivative requirements, which are more of the action items of how you go about carrying out these protections. The Nist expects that you will create these system security plans, which really explain how you are going to go about carrying out the protections, and then a plan of action to address gaps in the system. And this becomes important in terms of the DoD regulations, which have mandated the creation of these documents. All right, the current situation, as we said before, is somewhat ad hoc. And so the broadest regulation is the FAR, which establishes a system or a baseline system of 15 minimum level security requirements that are drawn from the Nist 800-171, but are intended to be the kind of things that a business would do in the normal course of protecting its own data. What's noteworthy is that it has to be flowed down to subcontractors. It effectively allows the government to assess your compliance, and that can have an effect on whether you win the contract or not. And the other thing of note is that there is no cyber reporting requirement. So the consequences of failing to adhere to this mandatory requirement are a little unclear. The DFARS, as I said, is the first agency that has gone out and established a comprehensive system to require compliance with the Nist 800-171. It requires the establishment of an SSP to describe what you're doing and a plan of action. And while it was unclear what you were expected to do, as Heather noted, DoD expects you to have a plan and a way to go about filling in the gaps that you haven't achieved yet. And the goal here with DoD and with any agency is if you get audited, you want to be able to show a good faith effort that you are working to meet the standards that are expected of you. The other aspect of the DoD regs is they establish a protocol for cyber incident reporting that allows for you to investigate, report within 72 hours, turn over the malware, and allow DoD into your system to check. Like the FARS, the agency gets to evaluate compliance, and the DCMA has now started to conduct cyber audits as part of its ongoing efforts. I turn to the other agencies we've noted briefly. The GSA and DHS have proposed regulations, and what we're all looking forward to is the proposed narrow rule that will mandate compliance with 800-171 for all. As a final point, as I started out, Your compliance obligations are not going to end with 800-171. If you're getting money from the state or local in a partnering arrangement, they increasingly are having their own rules. You still must comply with the privacy rules of HIPAA and PII, and if you're involved with Europe, you've got to meet the requirements of the GDPR. I thank you for your attention, and with that, I'm going to return it to Rob Van Arnam to answer questions and close us out.
Thank you, Tony, and thank you, Heather. We do have some questions from our audience, and let me read a few of them. We'll try to get to them quickly. I want to address this to Heather first, and then I can add to it. What has been the biggest threat to the educational system networks in the last few years?
Okay. I think one of the things that we see, not just in educational systems, but really in any complex organization, particularly healthcare is another industry where we see this, but the systems were not necessarily designed for data confidentiality. They were designed for accessibility and to really make the organization work. So now what we see is we're trying to build out an infrastructure that does now focus on compliance, or I'm sorry, focuses on security and confidentiality. Obviously the threats to these institutions are going to be similar to what we're seeing across the industry. Ransomware is always a big one. Having the ability to do backups and recovery and things like that will go a long way. Social engineering is probably the biggest. In fact, we've seen more of a decline in ransomware and more incidents recently having to do with social engineering that then installs malware, or even something as simple as getting someone to effectively give up a password that then allows access to the system. Rob, do you want to add on to that?
I agree with all of that. I would say one of the things we've seen recently is it's the weakest link principle, and that is you can have great encryption and a handful of robust compliance officers and folks, but if you've got staff and employees and people who click on a link or aren't properly trained or aren't thinking about security sort of constantly and have access to sensitive data, that is a gap in your infrastructure where people can get in. And we've seen sophisticated hacks, spear phishing, where it's a multi-level attack. They will maybe initiate ransom, then they will move to other protocols or introduce malware. It sometimes is a quick hit, but it often starts with the vulnerable, untrained, or unsophisticated employee or staff person who unfortunately has too much connection to sensitive data. Tony, let me start with you on this one. This is there's a few that are in the similar theme here, and it's how do you convince someone with a non-technical background money is well spent in protecting networks, and that related to sort of budget and budget outlays?
Yeah, I hate to sort of bring a storm and drang into that kind of a response, but, it's sort of why bother? I'll deal with it if the issue arises. And I think Sera-Brynn and you and I both know the emotional and logistical nightmare that occurs when there's a hack. You have to involve your lawyers, you have to involve a company like Sera-Brynn, and you're in a crisis mode. And your consequences flow from the rules that I spent a few minutes talking about, as well as a host of state and other regulations that affect what you need to do to respond. So in speaking with stakeholders, it's one of those dollar invested at the front end may well save $10 at the back end. It also creates peace of mind. It allows you to discover defects in your system, and like other compliance aspects, helps you build a more robust and forward-looking organization.
Great, thank you. One last one very quickly. Heather, how is the DoD CIO's office responding to notices after the 12/31/17 or the beginning of this year for incomplete compliance?
Sure. Again, and I talked about this a little bit during our presentation, if you have a system security plan and a plan of action and milestones, and they are both good, and they need to be well done. They need to have the right kind of information. Particularly the plan of action and milestones needs to have responsibility assigned to a specific person to implement those controls, as well as the specific steps that you are going to take or that are in the process of being taken, and a date for when that control is expected to be implemented. Then the DoD CIO has said that that is sufficient. But again, as we mentioned, this really hasn't been tested up until this point. We haven't seen any case law of the DoD coming after someone for not being compliant specifically with this regulation. So that remains to be seen. But obviously you can have those documents, but they are living documents. They need to be maintained. You need to show that you're making progress. And as an auditor, when I go in to look at a system, what I'm looking for is not necessarily perfection. I'm looking to make sure that you're compliant with the controls as written, but I'm also looking for improvement over past years.
Heather, thank you. That's great. We are out of time. There's a lot of material and information we've provided today, and several more questions we couldn't get to. Please reach out to us. We'd be happy to help answer questions. We make a great audit team to deal with the difficult compliance efforts that you're engaging in now. We really appreciate your time today, and we look forward to seeing you on our next webinars. Thank you so much. Bye-bye.